Senator Hawley.
Thank you very much. Thanks to the witnesses for being here. Congratulations on your nominations. Ms. Kobik, if I could just start with you. Let me ask you a question about the First Amendment, if I could. Does the First Amendment apply to the medium of the internet, in your view?
My understanding is that it does, Senator.
Why would that be true, considering that the internet didn't exist in 1791?
Well, Senator, the Supreme Court has adopted a number of different tests for assessing the constitutionality of different provisions. The First Amendment protects speech, of course, and people speak on the internet. But I would adhere to the relevant test if any First Amendment case were to come before me.
Well, I ask you because the Supreme Court has said something much the same in the Second Amendment context. And in the Second Amendment context, you argued to the Supreme Court that because a particular firearm did not exist at the time of that amendment's ratification, that it wasn't covered.
Hawley opens with a brilliant setup. He asks Kobik, does the First Amendment apply to the internet? She says yes, of course. And Hawley lets her agree to that, then springs the trap. The internet didn't exist in 1791. Nobody in Philadelphia was tweeting. Yet we all agree First Amendment free speech protections extend to the internet because the principle travels forward through time. So then why did this same nominee argue before the United States Supreme Court that a stun gun was not protected by the Second Amendment because it didn't exist at the founding? Do you see the contradiction? You cannot stretch one amendment to cover modern technology while refusing to extend that same logic to an amendment you politically disagree with. That is not constitutional interpretation. That is activism dressed up in legal robes. Hawley called it out perfectly.
The Supreme Court, covered by the right that is, the Supreme Court rejected your opinion unanimously in a per curiam opinion. That's the Caetano case. I've got it right here. You've been asked about it. You know, what's interesting to me about this case is there's a lot of division on the United States Supreme Court about a lot of topics, including the Second Amendment, but they were unanimous in this case. It's a very short order, 2 pages, not even, really, page and a half, in which they rejected your argument completely out of hand. And I just want to ask you, why did you make an argument that the Supreme Court said held no water at all, so much so that they felt the need to address it in a per curiam decision and to remand the case, saying that the arguments that you made were not to be countenanced at all? You didn't get a single vote. So tell me, help me understand, why did you make arguments that the Supreme Court said had previously been made and previously rejected by the same court?
Thank you, Senator. I just would like to clarify at the outset that I did not handle the Caetano case when it was before the Supreme Judicial Court. The case was handled by the district attorney rather than the Attorney General's office at that stage. In the Supreme Court, the argument that I made—
Wait a minute, you didn't, the Caetano case at the U.S. Supreme Court, you didn't handle it?
I did co-author the brief in opposition to certiorari at the Supreme Court,
Okay.
but not the Supreme Judicial Court.
I'm asking you about the Supreme Court, the Supreme Court judgment that rejected your arguments. So you've just confirmed, I think, that you made those arguments to the United States Supreme Court. Is that correct?
Respectfully, Senator, the argument in that brief was slightly different. The argument was that a stun gun is, we argued on behalf of the Commonwealth, not an analog to a founding era weapon.
Which the Supreme Court rejected unanimously.
The Supreme Court held that the Supreme Judicial Court had misstated the Heller decision in 3 respects. But again, I didn't handle the case in front of the Supreme Judicial Court.
So your argument is that your position wasn't rejected unanimously by the U.S. Supreme Court?
I certainly acknowledge, Senator, that the Supreme Court summarily reversed the Supreme Judicial Court's decision. And I would adhere to the Supreme Court's holding in Caetano and reaffirmance of Heller's statements.
Here's what I'm trying to understand. The Supreme Court was very dismissive of your arguments. One of the reasons it was dismissive is it said they've considered these arguments before and rejected them. This is why they then rejected your arguments per curiam, unanimously. So I'm trying to understand why someone who has ethical obligations to the court, why you would make arguments that the court has previously rejected, knowing that they'd previously rejected them. And then here's the other thing that interests me. In this case, the person who had been arrested under this law that the Supreme Court then reversed on was the victim of domestic abuse. And I just want to read a few of the facts here. This is from Justice Thomas and Justice Alito's concurrence in that per curiam judgment. Here's what they say. After a bad altercation, that's from the trial record, with an abusive boyfriend that put her in the hospital, Jamie Caetano found herself homeless and in fear of her life. So she obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, she accepted the weapon. And it's a good thing she did. Because one night, after leaving work, Caetano found her ex-boyfriend waiting for her outside. He started screaming that she was, this is from the trial record, not gonna effing work at this place anymore because she should be home with the kids they had had together. Caetano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. She stood her ground, displayed the stun gun, and announced, "I'm not going to take this anymore. I don't want to have to use this stun gun on you, but if you don't leave me alone, I'm going to have to." And the gambit worked. The ex-boyfriend got scared, and he left her alone. You think she shouldn't have had the right to self-defense?
Senator, thank you. Again, the district attorney made the decision to bring charges in the Caetano case. The Attorney General's office and myself were not involved in that decision, but I certainly recognize
that you argued for it to be upheld before the United States Supreme Court.
Senator, the argument in that brief was that the Supreme Court should deny review of the case.
Right,
But
which denied the right of self-defense to this person. I'm asking you why.
Senator, my duty as Assistant Attorney General was to represent the Commonwealth in that case when it came to the Supreme Court, and I did so consistent with my ethical obligations.
Your duty is not to make frivolous arguments to the Supreme Court of the United States. And frankly, I question your judgment in what you did in this case, and I question your judgment in choosing to try and perpetuate what is manifestly an injustice to this victim of domestic abuse. I yield the rest of my time.
Now the actual case Caetano versus Massachusetts. This is not abstract. There's a real human being at the center of this story. Jamie Caetano was a domestic abuse survivor. Her boyfriend put her in the hospital. She was homeless and feared for her life. She got multiple restraining orders, and they did absolutely nothing. Her abuser ignored them completely. When a friend offered her a stun gun, she took it. Thank God she did. One night, leaving work, she finds this man nearly a foot taller, outweighing her by 100 pounds, waiting outside, screaming threats at her. Jamie stood her ground, displayed that stun gun, and warned him she'd use it. He got scared and left. She was safe. Then Massachusetts arrested and prosecuted her for possessing it. The legal system failed to protect her from her abuser, and then when she protected herself, the government prosecuted her for it. That is a profound injustice. And Ms. Kobik co-authored a brief asking the Supreme Court to let that prosecution stand. Here's what really gets me. The court didn't issue a close 5-4 ruling. They issued a unanimous per curiam opinion, meaning the whole court together, no individual justice's name on it, reversing the decision. That is the Supreme Court's way of saying this is so clearly wrong, it doesn't warrant serious deliberation. They also noted these arguments had already been previously rejected. So Kobik wasn't just making a losing argument. She was making one the court had already told everyone doesn't fly. Hawley asks her directly, why advance arguments the court has already rejected? Her answer, essentially, I was doing my job, doesn't cut it. I'll be fair, government lawyers sometimes must defend positions they personally disagree with. That's part of the role. I understand that argument. But there's a difference between faithful representation and making arguments already definitively rejected by the very court you're standing in front of. Professional judgment has to kick in at some point. The human cost here was too high. Jamie Caetano was not a criminal. She was a victim who did everything right and still got failed by the system until she protected herself. This is why judicial confirmations matter, folks. The federal bench is where your rights live or die long-term. We've seen activist judges treat the Second Amendment as a second-class right repeatedly, bending over backwards to uphold gun restrictions while never applying that same scrutiny to the First or Fourth Amendments. When a nominee has a documented record of making anti-Second Amendment arguments, so weak the entire Supreme Court rejected them unanimously, that is absolutely relevant to whether they deserve a lifetime judicial appointment. Hawley did his job. He came prepared, read the case, understood the facts, and held this nominee accountable. That's exactly what the confirmation process is supposed to look like. The Second Amendment is not negotiable. It is not a government-granted privilege. It is a constitutionally protected right, and it covers the tools that exist today, just as the First Amendment covers the internet today. Jamie Caetano deserved better. Every law-abiding American who wants to protect their family deserves a judiciary that takes that right seriously. Drop your thoughts and comments. I read everyone. Share this video, and I'll see you in the next one. God bless you, and God bless America.